violent crimes have skyrocketed across the country in 2023, more people than ever want to know how to get carry permits, particularly in places with historically strict gun laws. I'm attorney Leigh with Markham Law Firm, here to talk to you about the requirements and process for getting a carry permit and appealing the denial of a carry permit in the District of Columbia, a jurisdiction with some of the strictest gun laws in the country. Please subscribe to Markham Law Firm's YouTube channel for more informational videos like this one. DC carry permits are called Concealed Carry Pistol Licenses, or CCPLs. I'm going to refer to them as carry permits throughout this video, because who can handle another government acronym? How do you apply for a carry permit? The application for a carry permit is on the Metropolitan Police Department website at mpdc.dc.gov. After completing the application, the applicant must make an appointment with MPD and bring their completed application and several other items that we'll discuss in a minute to the Metropolitan Police Firearms Registration Section at 300 Indiana Avenue in Northwest DC. What information do you need to complete the application process? In order to successfully complete the application for a carry permit in DC, the applicant must provide a statement of eligibility, information regarding their firearms training and background, and the applicant's authorization to disclose mental health records. MPD requires that the applicant have completed at least 16 hours of firearm training from an MPD certified firearm instructor, as well as 2 hours of range training from an MPD certified instructor. The district also requires training in DC laws on firearms and self-defense unless you are exempt. So what is a statement of eligibility? Well, exactly that. It's a form found on MPD's website with 14 questions that you check off yes or no to confirm your eligibility to possess a firearm. You sign the form under oath, so please be honest or you may need to call me to represent you. And who is exempt from the DC training requirement? On a case-by-case basis, the chief may exempt a person who submits evidence that he or she has received firearms training in the U.S. military or has otherwise completed firearms training by a firearms instructor that, as determined by the chief, is equal or greater than that required by DC law. So who decides whether you get your permit? The chief of MPD does. There's a provision of DC law that you should know about that gives the chief substantial power to deny a permit to someone who has, within the 5 years immediately preceding the application, had a history of violent behavior. We've had clients who have been denied permits solely based on protective orders that were dismissed and where a judge made no negative findings. So this does not require a conviction. How long will it take to get a carry permit? Generally, MPD is issuing permits within about 90 days once all of the documents have been received by the registration unit. If a more in-depth background check is required, it could take longer. Why might a carry permit be denied? Well, we've already talked about having a history of violent behavior within the 5 years prior to submitting your application. Other reasons you may be denied include, but are not limited to, being convicted of a weapons offense in any jurisdiction with the exception of some misdemeanors, being convicted within 5 years prior to the application of any drug offense, threats to do bodily harm, assault, whether or not offensive contact was made and whether or not it was a misdemeanor, 2 or more violations of the DC DUI laws or DUI laws in other jurisdictions. This probably includes diversion if there was an admission of guilt, an intrafamily offense or domestically related crime regardless of whether it was a misdemeanor or felony, stalking, negligent storage of firearms. If a person has been voluntarily or involuntarily committed to a mental health facility, if the person has been adjudicated negligent in a firearms mishap, has been a respondent against whom a protective order was issued unless the order has been expired for at least 5 years. So what if your application is denied? Well, then you can appeal to the Licensing Review Board within 15 days of the chief's decision. You must submit a copy of your firearms registration certificate or approved PD 219 application, a copy of the denial letter, and a detailed description of why the chief's denial was improper. Authorization for an attorney's representation if an attorney has been hired to assist with the appeal is also necessary. While an attorney is not required to assist in submitting an appeal, it can be highly beneficial to reduce stress, assure compliance with the law, and proper submission of the application materials. I hope you found this video useful. Please subscribe to my YouTube channel to receive more informative content like this. I'm also open to suggestions on other topics, so leave a comment if there's a subject that you would like to hear more about. Again, I'm Attorney Morgan Leigh, and I will see you next time.